All right, good morning, everyone. My name is Chris Newman. I am a faculty member here at Scalia Law. I do teach a doctrinal course on the First Amendment. And I get the honor and pleasure of moderating this panel on a really interesting and important topic. The title of our paper is The First Amendment Rights on Trial, a Critique of the Time, Place, and Manner Doctrine. Our paper author is Alec Graven, who is, amazingly enough, only a JD candidate at the University of Chicago Law School. He has, however, been working in the policy space of free speech for quite some time. He has a Master of Public Policy from the University of Oxford. He worked as a research fellow at the Institute for Free Speech and has published numerous articles on free expression issues. We're going to hear from him giving us a brief overview of his paper, and then we're going to get commentary from two very knowledgeable and distinguished commentators. We have Emerson Sykes, who is a senior staff attorney at the American Civil Liberties Union. He litigates First Amendment cases as part of the Speech, Privacy, and Technology Project, and he's also an adjunct professor of law at NYU School of Law, where he teaches a seminar on race and the First Amendment. And we have Tim Zick, who is the John Marshall Professor of Government and Citizenship at William and Mary Law School. He teaches First Amendment and other constitutional law courses. Professor Zick is the author of 5 university press books on First Amendment and co-author of a First Amendment casebook. And his most recent book, which is relevant to our topic, is Managed Speech, the Law of Public Protest. All right, so I'm going to give each of our panelists about 8 minutes to give an opening review, opening remarks, and then we will try to have some discussion up here, and then we will open it up for a broader discussion with the audience. So I'm going to give each of them, I'm going to flash them a sign when they've extinguished 5 minutes of their time. So I'll give you a 3-minute one. In other words, you have 3 minutes left, and then I'll show you have 1 minute left so we can keep the trains running on time. So with that, take it away, Alec.
Thank you. Thank you. Sorry, can you hear me all right? All right. Thank you so much for the opportunity to present my draft paper today. Sorry, I don't know what the echo is.
Yeah, we're getting some feedback.
So I decided to focus on time, place, and manner restrictions and the threat the current doctrine poses to First Amendment assembly rights. TPM restrictions are a long-established aspect of First Amendment law and generally allow the government to regulate the time, place, and manner of speech so long as the regulation is content-neutral, narrowly tailored, and leave open ample alternative channels for communication. TPM restrictions fundamentally aim at creating an ordered system of expression and so place constraints on speech that has the tendency towards disorder. This can be very problematic for social movements, which are the product of time, place, and manner, and often use disorderly elements to convey their message in unique and profound ways. If the state is given too much discretion to regulate assembly, they will also be able to suppress or burden social movements that they disfavor. My article argues that the current TPM doctrine has failed to properly maintain the balance between order and expressive freedom by granting TPM restrictions far too much power at the expense of free expression and association. I argue in my paper that there are 3 major weaknesses with the TPM doctrine. First, the doctrine says that a TPM restriction can be upheld if it keeps ample alternative channels in place. However, digital communication allows almost any message to be expressed through the internet or social media platforms without a physical presence. But physical assembly and demonstrations convey unique and profound benefits to social movements. And so if there is a loss to physical assembly, then there will be a loss to the communication efficacy of social movements. Additionally, the standard threatens to deprive people of the freedom to express their views in the forums that they choose. People tend to rationally locate their speech in the time, place, and manner where they think it will be most effective. If courts change the chosen location or venue of someone's speech, then they will almost always compromise some measure of the speaker's effectiveness and in that way abridge their speech in some manner. So following the First Amendment scholar C. Edwin Baker, I argue that this standard can be improved by modifying the TPM doctrine to say ample equivalent channels rather than ample alternative channels. This change will help make the TPM doctrine a meaningful safeguard against government authorities being able to abridge freedom of speech and the effectiveness of speakers. And the Supreme Court should also clarify that in almost all cases, a substitution from a physical forum to a non-physical forum is almost never equivalent. The second major issue with the TPM doctrine is that content neutrality standard is too easily satisfied. One of the key issues is the secondary effects doctrine, which is a standard the court allows the government to single out content, often content that is unpopular, socially stigmatized, or unpopular, and then justify its regulation as a secondary effect while picking between an almost endless supply of primary effects. I argue that the Supreme Court should repudiate the secondary effects doctrine because it deprives the content neutrality standard of all meaningful force. A related concern with TPM restrictions is that many restrictions are facially content neutral, but there are vast disparate impacts on different speaking groups. This is because certain groups tend to use areas disproportionately for speaking purposes. For instance, protesters outside of abortion clinics are almost always pro-life, and demonstrations outside of the IRS building are almost always anti-tax. Policy officials often know this and know that the use of these forums is used disproportionately, and so can impose content-neutral requirements with the aim of disproportionately burdening certain speaking groups. Legislators hostile to abortion critics know that restricting speech outside of abortion clinics will silence much more speech that is opposed to their position rather than is aligned with their position. Therefore, if courts close their eyes to efforts to disproportionately burden certain speaking groups, it enables the abuse of government power contrary to the First Amendment by using illicit motives. I argue we can fix this problem by conducting a more serious motive inquiry into what drove the passage of legislation in the first place. We should regard a regulation as content-based when that regulation otherwise would not have been passed but for the presence of impermissible motives. And if there is a facial showing of impermissible government motives behind the regulation, then the burden of proof should shift to the law's defenders to show why the regulation is not content-based. And this burden shifting is a critical element to balance equities between the parties who have to meet pretty demanding burdens of proof. And the third major issue is selective enforcement. Selective enforcement is when a government official takes action on facially valid grounds against someone based on their expression and political belief, but fails to take action against similarly situated individuals who express more palatable things. For instance, a police officer has the right to charge someone for jaywalking, and officers have broad discretion over what kinds of charges they can issue. However, there would be a clear First Amendment issue if a police officer only charged anti-police protesters with jaywalking and avoided other protesters who are engaging in similar offenses. Selective enforcement allows the government to place its thumb on the scale and amplify favored groups while silencing and punishing groups it disfavors, while shielding itself under purportedly neutral laws. In 2019, the Supreme Court ruled that the presence of probable cause should generally defeat a First Amendment retaliatory arrest claim. And this is concerning because there are so many broad charges out there, such as disorderly conduct. That means that the probable cause standard will usually be satisfied in most public assembly contexts. I argue that this doctrine can be improved by shifting the burden of proof to law enforcement when there is a plausible evidence that the law enforcement official acted with impermissible animus against the speaker. All of these proposed changes impose reasonable constraints on government discretion when implementing and enforcing TPM restrictions and will safeguard against abuse of First Amendment rights. In this way, reform of the TPM doctrine will help us facilitate more free speech and social progress while safeguarding the vitality of future movements that are to come. Thank you very much, and I'm looking forward to diving into these topics in more detail.
Excellent. Thank you very much, Alec. We will next go to Emerson.
Thank you very much. Thanks to Alec for writing such a strong piece. Thanks to Joanne Coop for the invitation, and thank you all for being here. It's an honor to join you all. I'm sort of wearing my practitioner hat, so I wanted to make a couple of general comments about the paper, which I think is very strong, and then see if we can work through each of the three primary recommendations of the paper, and I want to apply them to cases that I have right now that are actively looking at these types of issues. So first, again, thank you for having me. I think, the first thing that strikes me that I think might warrant some attention is the framing of the paper in terms of TPM. And I think, it's used in many different formulations. We talk about TPM doctrine, TPM restrictions, TPM requirements, TPM standards. And I think the way that maybe this is wrong, there's a lot of great law professors in the room, so I'm embarrassed to say this, but the way I think of TPM in general are the kinds of restrictions that are okay, right? Like when we're talking about restrictions on assembly, time, place, and manner restrictions, so long as they meet the requirements set forth by the Supreme Court, are the kinds of regulations that are acceptable. So we think of it as mostly as a positive thing, in contrast to content-based or viewpoint-based restrictions. So I think just sort of framing TPM in this way and sort of how it's used generally might be helpful in terms of being more specific in terms of what types of regulations, requirements, standards, rules we think need to apply in these different places. And TPM, I think, is useful in some places, but not so useful in others. So again, sorry for those of you who haven't read the paper, because maybe that's not so useful, but I could have sent that an email, but here we are, this is a symposium. So I think I 100% agree with the problems that have been highlighted. These are things that come up in our litigation constantly, right? These three problems that Alec has highlighted. So the first is about alternative channels, right? This is something I'm sure we've all thought about. Alec addresses many cases where courts have seen fit to allow protests to be moved to a place where they can't reach their audience, moved to a place that is significantly different from the place that they originally wanted to protest. And this raises obvious issues. So I think the fix makes sense. I don't know how likely it is that Supreme Court will edit itself with one word changed, but I think it's true that it would be better to have a test that was about equal opportunities rather than alternative opportunities. And I think the issue that Alec highlighted most starkly, there's a case that I wasn't aware of actually out of the First Circuit, where the court basically found that being online is an alternative to an in-person protest. And I think, Alec, as you present this, it's sort of the most shocking example among many examples, but I honestly think that it's a bit categorically different from the physical movement places. So I think it might bear even more highlighting, because that seems like a bright line rule that courts should never find that a completely materially different mode of communication is an alternative. But when we get to what I call the tape measure cases, it gets difficult to really say what is equal and what is alternative. We litigated a case recently in Graham, North Carolina on behalf of the NAACP, and they wanted to protest against a Confederate monument outside of a county courthouse. And so literally we had to go through over the course of the litigation and say, how big is this parking space? Is that really a parking space, or is it a designated area for something else? Can we use that as for counter-protesters? Can we use that for pedestrians to walk through? What is the nature of this crosswalk? It's not lined. Is it a real crosswalk? What is it? So it gets really, really, really detailed about, physically, where can you put people and keep them safe? And I will say that protesters often have an interest in buffer zones. We complain about buffer zones, we complain about protest zones, but when you've got a lot of people in a tight space, sometimes they're necessary. So all this is to say, I agree that it's a huge problem. I think that finding by the First Circuit is shocking. And I think the devil is going to be in the details in terms of what is actually equivalent. Is being across the street equivalent? No, it's an alternative. It seems to me a viable alternative, but it's not quite an equivalent. Whereas the online move is not only not equal, but it doesn't seem to even be a valid alternative. So I wonder if maybe what we think is that First Circuit court case was just wrongly decided, and we don't need to necessarily change the wording of the test. We just need to change the application. So that's one suggestion. Got it. Secondary effects. So this is the second part of the paper, and this comes up in the context of sexually oriented businesses, right? Like We're not regulating them because of what they're saying, we're regulating them because of all the stuff that happens outside, right? And so, Alec, you do a good job of pointing out the relationship between facially content-based regulations that are deemed to be content neutral through the sort of magic of the secondary effects doctrine. But it also brings, but your fix, which is to look into the motive, just to quote, it says, the framing question should be, but for the presence of impermissible motives, would the regulation's disparate impact on content have differed? So what came to mind with me is the drag bans that we're currently litigating across the country. I just found out the Fire lost their case in Texas A&M. Sorry, guys. But the drag ban that we've been pushing against are sort of adjacent to some of these secondary effects, right? They say you cannot perform, they vary in their language, but a lot of them say you cannot perform in clothes that do not align with your sex assigned at birth, unless you are in a quote-unquote adult-oriented business. Or by hosting such an event, you automatically become an adult-oriented business, and therefore you will be regulated as such, right? You've got to be across the train tracks, you can't be around a school, you can't do any of these things, right? And this would apply to a cafe that hosts a drag brunch once a month or something like that. So with that in mind, as this sort of very facially content-based regulation, I'm curious as to how the motive inquiry might proceed, right? Like, I'm foreseeing a debate about these folks are saying they're doing this to protect children from groomers, right? And we're saying their motive is anti-LGBTQ. And so when we get into a motive inquiry in this area, it makes me a little nervous to sort of sort out how genuinely held are those beliefs. I think some of them might actually believe that they're helping children, right? So the motive inquiry, I think, might not totally untangle us. And with my last minute, I'll talk about selective enforcement. So here, another huge problem, right? Facially neutral laws that are applied in a selective way. This is something that we've seen over and over again. We recently represented the Southern Utah Drag Stars, where they were trying to hold an event in a public park, and the city council scrambled. We, through discovery and public records requests, have uncovered this information. They scrambled to find any way they could possibly find to stop this. And somebody in the office came up with a law that had never been used, a policy that had never been used, that prohibited advertising before the event is approved. But the city council doesn't approve events, traditionally, until the night before the event. So if the advertising prohibition were enforced, no one could ever advertise for an event. And what our client is accused of doing is putting a posting on a website looking for vendors to set up stalls at her event. And that was considered to be violating the advertising prohibition because she hadn't gotten her permit yet. So the question we had, and the question I would have for you, is what kind of evidence of animus do we need to show the selective enforcement? Here it was easy, right? They had never used the law before, and this was the first time. But I'm curious as to if we're thinking that we need evidence of animus to get around this terrible Supreme Court ruling that probable cause does away with the First Amendment inquiry, what kinds of evidence do we look at? Is it statistical evidence? Has it never been used before? There's lots of cases where it's actually a lot more mixed. We think it's selective, but it's not that it's never been used before. And then the question would be, is a government official statement enough for animus? And can that then be attributed to the body as a whole? So I'll stop there. Thank you so much for the opportunity. Alec, great job, and I look forward to the discussion.
Great, thank you. Tim?
Yeah, my thanks to the organizers for the invitation and to Alec for writing this terrific paper. As Chris mentioned, I've just finished a book called Managed Dissent to Law of Public Protest, and in that book I explore this delicate balance between maintaining public safety and order on the one hand, but also protecting robust free expression rights on the other. And there are a myriad of obstacles to effective public protest, aggressive protest policing, public order laws that are inherently discretionary in terms of their enforcement, civil liability rules, the presence of firearms at protests and hostile audiences at protests, sometimes both of those things. And as Alec helpfully reminds us, the time, place, and manner doctrine itself, which inhibits and limits protest activity in various ways. So like Emerson, I'm going to walk through the three different areas here and say something briefly about each of them. I'll start with ample alternative channels. I always found that phrase to be weird. I don't think ample is the question at all. Ample puts the fix in because you can always find somewhere else to speak. And now that there's online speech and cheap speech and that's all proliferated, it's very easy for the First Circuit to say, well, if you want to get your protest message across, and the case in the First Circuit was about a national political convention, people who wanted to protest that, you can just go online. Or in another case where the court upheld a restriction on overnight camping in the DC parks, it said you could contact the media, as if the media would inherently be interested in what protesters had to say. So I think there was a mistake in the beginning in Ward versus Rock Against Racism to adopt this ample alternative channels focusing on plentifulness rather than the characteristics of the so-called alternatives. I'm not quite on board with equivalence because I think it's going to be very difficult, not just for courts to adopt it, but to sort of put that into practice. So Alec mentions in the paper you'd consider, for example, quote, how much speech is lost when an alternative channel is enforced, or the efficacy of these channels. I think something like a reasonable opportunity to engage with an audience at a location the protesters intend. And in my first book, Speech Out of Doors, I focused a lot on place and how it relates to free expression and public protest, and tried to get courts, scholars interested in the concept of place, the notion that speakers didn't just randomly show up to protest. Typically, they intentionally choose a place to go, a location, and they do that to reach particular audiences, and sometimes because the places themselves are highly symbolic and vocal. So there's a lot being lost when you say to protesters, you can have access to other ample or plentiful alternatives, but not to this place. Having said that, it is sometimes not possible to provide, I think, an equivalent channel of communication. Sometimes it's just a matter of local geography. There just isn't a space to do it. It could be that there are national security concerns with respect to some large-scale protest. So I think you have to give some room for discretion or flexibility, and I think equivalency might go too far. And when you say ample equivalency, you're sort of doubling it. So there has to be sort of both equivalency of characteristic, but also an ample number of equivalent alternative channels. So that's what I have to say about the alternative channels part. Secondary effects, motive, and purpose. I think that too much credit might be given in the paper to this doctrine, which has generally been limited, at least in the Supreme Court, to erotic speech. Nowhere else has the court adopted, allowed the government to say, we're regulating speech, even though it looks like it's content-based, our regulation is really about the secondary effects of expression. And there are plenty of cases that I think undermine any notion that the court would adopt that principle for political speech, generally speaking, including Reed versus Town of Gilbert, which I think the paper should pay more attention to. The court's most recent explication of content neutrality and what that entails. I think, anyway, even though the court doesn't mention Renton and Young in these secondary effects cases, I think it all but overrules them. It just doesn't actually say so. And there are other cases where the court has made clear you can't rely on, for example, the prospect of violence as a secondary effect to limit a public protest. So I think there's plenty of authority to, and I agree with you, to do away with, to finally inter the secondary effects doctrine. With respect to motive, like Emerson, I think I'm a little bit skeptical. And in some of the cases you mentioned, I think just a faithful application of content neutrality rules would do. Hill versus Colorado is a great example. The Colorado law that prohibited unconsented to approaches to educate or counsel near abortion clinics, I think is content-based, just using the ordinary content neutrality rules. I don't need to know anything about the motive of the Colorado legislature in that particular case. That said, there are cases where I would like courts to be more skeptical and not close their eyes to context, right? Funeral protest laws are about the Westboro Baptist Church, right? They proliferated once that group used funerals to amplify their message, targeted a protest at residences, addressed a particular problem. The sidewalk counselor restriction, same thing. So I think I would like to see a little more skeptical review, at least where governments target particular modes of speech or particular kinds of speakers. Last, on selective enforcement, I'll just say this. I totally agree that Neves versus Bartlett is a terrible decision. My own research on this, I'm doing a piece called Public Protest and Governmental Immunities, and I've been trying to track, well, what's going on in the courts after Neves versus Bartlett, and as one would predict, the courts are generally upholding probable cause determinations and eliminating the retaliatory speech claims in protest cases. I'm looking specifically at protest cases. So I think a congressional fix or a court fix would be terrific there. The problem, largely speaking, seems to be one of discretionary enforcement of time, place, and manner laws. That's I think, what you're aiming at. And it's not really time, place, and manner regulations in those contexts. It's public order laws like breach of peace, disorderly conduct, conspiracy to riot. And you mentioned this briefly in your paper, and I wanted to get your thoughts on it here. Maybe you could elaborate. There are scholars that have taken the view that you should repeal those offenses entirely, that they're so shot through with discretion you shouldn't have breach of peace, disorderly conduct, or in the alternative, you should make efforts to narrow them, to remove some of the discretion that law enforcement has to enforce them. That's a more radical, drastic step, but I wonder what you think of that. I'll stop there.
All right, thank you. We've got a lot of great topics on the table. I want to start actually by asking, about this first issue, the one about how should courts go about trying to decide when the location of a protest or the desired location of the protesters from which to promulgate their message is one that has such important expressive content to it inherently because of the nature of the place, that it should place some sort of heightened burden on law enforcement in making, the kinds of, Emerson, I think, in his remarks acknowledged, both of our commentators acknowledged that there are bona fide public safety concerns when you have mass protests, and especially if they're going to involve counter-protests, where there are legitimate public safety concerns. And so I'm trying to understand, it seems like what you're doing in your paper is trying to push courts to articulate some version of scrutiny that gives more weight perhaps than they are now to, the speaker's choice of location. But I think you recognize that it can't be absolute. It can't just be that, this is obviously my preferred place to give this, would be from the floor of the Senate, but they're not going to let me do that. And maybe they have valid reasons for not letting me do that. And so the question is because at the end of the day, you want judges to have a test that they can actually apply, right, with some sort of, doctrinal consistency. And you have to find a way to articulate that with, elements that are going to be justicially manageable. And so what is the best, your best thoughts about how we can do that? Would you like to give us your thoughts, and we'll ask each of the panel members?
Yeah, so I think it's a really good point. And one thing I clarified in the paper is ample equivalent channels should always have this point of reference to what individuals have the right, locations where they have the right to speak in the first place. So an individual can't just go into the Oval Office or the floor of the Senate and make a speech and say, you're depriving me of these channels, I'm now owed a redress, because they didn't have that right to use that forum in the first place. But certain places like public streets, if the government comes in and limits access to the public streets because of some kind of national security issue, such as I was thinking the curfew, mass curfew ordinances in the 2020 BLM protests, which basically eliminated the right to physically assemble, I think there is no ability to offer an alternative, an equivalent channel in this case. And so that doesn't mean that a curfew, in my mind, can never be imposed. It just means that the standard of scrutiny that the courts should apply should raise. And so for something as severe as a limitation of like a curfew violation, I think that those curfews should have been subjected to strict scrutiny, that we should have raised the level of inquiry. And I think in like very legitimate cases where the government actually does have a good reason to impose certain curfews in times of serious general unrest or serious national security concerns, then the regulations will meet a strict scrutiny analysis. And I can imagine, just raising that bar of scrutiny in maybe like lower level cases, such as like buffer zone cases, where it isn't like an imminent national security issue, but it's at least a little bit higher. And so, yeah, as you mentioned, I think the core issue is when the speakers lose some ability to express themselves in a forum which they, in ordinary circumstances have the right to, that there's a higher level of scrutiny on the government to meet that.
Okay, what do you think, Emerson? How workable does that sound to you?
Yeah, I mean, I think it makes sense. I think the idea, one of the things I think we can clarify a little bit in the next draft is this sort of what are the implications when the new rule isn't followed? And I think the idea of, you answered the question of this is about a higher level of scrutiny. And I think that does, rather than it's not allowed at all. And so that does seem like a decent fix to me. I do think it doesn't fully address the issues we talked about in terms of equivalency and finding that, but I do think it makes sense to think about it as if you fail to meet this standard, then you ratchet up the scrutiny rather than that's the end of the inquiry altogether.
So is the idea that anytime the public officials want to require protesters to change their physical location, that triggers some version of heightened scrutiny? Is that what we're saying?
Well, I thought Alec was saying if you're losing significant speech. Well, I don't know if that was your formulation or Alex. The losing significant speech, then that even if it's facially content neutral, it would trigger strict scrutiny because it has had an impact on speech. Is that right, Alec?
Yeah, and more substantial loss. So maybe if you move it just to the other side, that might be an equivalent standard. But if you move it to the other side and you completely are now out of sight of your intended audience and the audience can no longer hear you, then those would be standards that you could apply. But if, you could still see them and, those would be, they could still hear them, you still have access to the audience, then that wouldn't have strict scrutiny analysis because it would still be an amply equivalent mode of expression.
Okay, do you want to weigh in, Tim, on that?
Yeah, I mean, my view on this is you have a standard intermediate scrutiny that's not supposed to be a rational basis standard to begin with, right? Part of the problem is the standard isn't being applied strictly enough in general. So I don't need a new standard. I need courts to actually enforce the standard that the Supreme Court announced. And the way I would go about this is to try and take into account what I call the vocality of place or the communicative aspects of place within the time, place, and manner test itself. And the Supreme Court has shown itself quite willing to do that sometimes. So, for example, in McCullen versus Coakley, which involved buffer zones around reproductive health care clinics, the court went out of its way, I think, to say that sidewalk counselors need access to a particular audience at a particular time, just as Kennedy once called this proximity and immediacy. They struck down the buffer zone law because it was not properly tailored under this intermediate scrutiny standard. So when they want to, the justices are quite willing, I think, to add some teeth to a standard of review that can sometimes seem rather toothless, right? So here's another example. I think I've already mentioned the case involving people who wanted to sleep on the National Mall to demonstrate the plight of the homeless. And the location of that protest really didn't come into play at all for the majority opinion. Only the dissent mentioned it. It's the seat of government, right? To tell people, well, you could go talk to the media instead seems to deny entirely the vocality of the location that they chose. And to say that aesthetics is a significant interest, right? It's essentially outweighing their right to protest there, is again, I think, an example of how you have this intermediate scrutiny standard that's not being applied with much vigor. I'll put it that way.
So that's sort of an interesting one, though, because you could imagine people trying to leverage that right, if it were more robustly protected, to basically say, okay, great, we can set up camp and live here in this park, because on doing that on an ongoing basis is our protest, right? And that might even be, you know, you could imagine that being done opportunistically, but you can also imagine it being done with sincere expressive intent.
Sure.
And so, I mean, do we have to have some idea, is a protest inherently a time-limited activity? Or if it's not, then, I mean, you see what I'm saying?
Yeah, I mean, that was the Occupy Wall Street
Right,
problem.
right, exactly, that's a great example.
Yeah. I mean, I think there do, of course, have to be limits, but the problem is you never get to talking about the limits, because you just say, well, you don't have a right to protest here in this manner because it hurts the lawn.
Okay, so let me actually ask, you know, it's interesting that we're having this entire discussion under the rubric of TPM, under the rubric of free speech. And there's this other part of the First Amendment that I seem to recall having read at one point that said that there's a separate right about the right to peaceably assemble. And I'm wondering whether maybe we should be trying to dragoon that clause into, when we're having a discussion like we are right now, specifically about the importance of physical protest in a particular location. And you know, as I think some of you have articulated, it might be difficult to get the Supreme Court to revise the doctrine or the, you know, the formula that it's thrown out for TPM stuff. But it seems like it's there, the slate of doctrine interpreting and construing and applying the right to peaceably assemble seems like it's a lot less overwritten than the doctrine of free speech. I'm not aware of that. I mean, it doesn't seem like that gets invoked very often in these cases. Maybe I'm mistaken about that. But I mean, is it possible that that's an alternate vehicle that's more tailored toward dealing with this specific type of problem? Because it precisely is about the idea that, forget about whether it's more or less effective as a speech thing. You have an independent constitutional right to peaceably assemble. Now, it doesn't say where, I suppose, but I mean, is that a potential vehicle for getting a line of jurisprudence that's more tailored to this specific problem and that doesn't, I don't know, what do you think?
I think it's a very interesting point, and I definitely think the Supreme Court should address kind of this right to peaceably assemble more more generously. It's really been it's been a very neglected part of the jurisprudence. I would highly recommend John Inazu's work. He's a public assembly scholar on this, and so I do think it would be a useful hook. But I'm also slightly worried that if you propose this right and the court has been hesitant to invoke it in the past, then they'll just ignore, you know, kind of invocations of it in the future. Whereas like TPM doctrine is a very established kind of clear-cut right. And so that's almost like a existing hook that's, you know, kind of used. So that was one of the reasons why I went more of the TPM approach, because that is an existing strong hook that the court recognizes. But I'm also very sympathetic to also, you know, highlighting this right of peacefully assembling as well. And I also think they do go hand in hand. They are separate rights, but they are very complementary.
Good.
I don't know if this is the right time to bring this up, but this reminds me of a sort of bigger issue that I think might need to be spelled out a little bit more clearly in the paper, but I think it also implicates sort of what the recommendations are, and specifically to whom. So when we think about these regulations, there's at least a handful of parties involved, right? There's the protesters themselves, and they need clarity about what the rules are so that they can know whether to follow them or decide not to follow them and engage in some sort of civil disobedience, right? So the protesters need clarity. The officials also need clarity, the ones who are going to be enforcing these rules, the police officers, the city council who's approving the permits, the county sheriff, all these folks, right? So they also need clarity, and they need to be held accountable when they violate people's rights. And then we get to assuming that you have the protesters and the officials have done something problematic, then you have the litigators who are trying to bring these cases, and I think they also have to figure out how best to frame their arguments and what to emphasize and those sorts of things. And then we get to the hardest part, which is the courts, right? And so then we have the lower courts who are left to interpret these rules while SCOTUS is, you know, pronouncing the general standards. And I think this is not, you are nuanced about this in places, I think, and want to recognize that. But I think it's a thing that happens in many law review articles, that we kind of just focus on what the Supreme Court should do to fix this. And we wish they would do all sorts of things to fix all sorts of things. And both for practical reasons, and I think also, as we said, because the standard as it exists is not obviously unworkable, not necessarily obviously unworkable or needs to be totally abandoned. With regard to alternative channels, I agree that secondary effects should be abandoned. But I wonder if the focus shouldn't be on encouraging lower courts to have a narrower interpretation. And I think that is a place, like lower courts do look at journal articles. I mean, the Supreme Court does too, but lower courts look at journal articles for how to interpret Supreme Court standards in the best way possible. And so I think that might be the key area of influence in terms of trying to sort of get folks to either ignore some of these bad rules and to sort of narrow up some of these things that have gotten more expansive. But maybe this is also my sort of litigator bias, but focusing on the role of the lower courts seems key.
Cool. Tim, do you want to weigh in on this?
Yeah, on the assembly point, I'm glad you mentioned John Inazu. Tabitha Abu-Alhaj has done terrific work on that issue as well. The problem is the free speech clause has just swallowed the rest of the First Amendment, the press clause, the assembly clause, the petition clause. It's made some inroads on free exercise, but that's still, I think, a pretty robust constitutional protection. As for fixes, I mean, I don't know. I don't want to let law enforcement off the hook here, or local officials, or even legislators, quite frankly. I mean, they keep passing laws that are speech restrictive in response to every mass protest. You get an avalanche of laws about we need harsher penalties, we need more public order laws, and you know, the aggressive policing has been a problem for many decades. I don't know if the breakthrough is going to happen ever with law enforcement, but I wouldn't want to stop trying there as well, because a lot of what your paper talks about is enforcement discretion and how to deal with it, and I think dealing with that through the courts is good. It's fine, but there are other actors here that need to be convinced.
Some of them are more likely to read law review articles than others.
Okay, well, that's a great segue to another topic. I mean, this question of, I think Tim was suggesting that we needed to either overturn or vastly narrow things like breach of the peace laws or things like that. And so, I mean, obviously this is a difficult problem. The more discretion law enforcement officials who are on the ground have, the more discretion they have, the harder it is to objectively identify biased, discriminatory use of that discretion. On the other hand, the more you try to sort of rigidly regulate exactly what sorts of disturbances can they respond to and how, the more you create rigid categories, then that means they're going to be less flexible in terms of dealing with, situations that are, in the real world is always in flux and not always neatly fits into one of the prescribed categories. And it may even in some cases cause cops to do things that are more harsh than they might otherwise have done because they feel like, oh, I have to go by the book and do exactly what it says in response to this, otherwise I'm going to be accused of bias, because, and so there's pros and cons either way. So I'm wondering, it sounds like maybe you're saying best practices would be we need police departments or city officials who oversee police departments to try to come up with best practices for these situations? I mean, would that be something that is best promulgated in the form of some kind of regulation or more as a form of principles? What's more likely to be actually understood and used by actual police officers? Do you have actual thoughts on this?
Yeah, and so I think you captured the dilemma very well, because my proposal, some scholars like Rachel Moran, she has an article doing away with disorderly conduct, talking about the very vague grant of power that like a disorderly conduct charge does, some certain breach of the peace statutes. I agree. A lot of these statutes are quite broad. I think there is probably areas where the language can be narrowed, where they aren't completely rigid, but at least can narrow them down a little bit. And there is a nice section of Supreme Court cases that relate to permitting restrictions, where the Supreme Court struck down a bunch of permitting schemes that cities had because they vested government officials with way too much discretionary power. And so I think the courts should be sympathetic when they're seeing certain standards that invest officials with way too much discretion, then they should either narrow that or limit those kind of policies. And so I don't think I'm quite there with we should completely get rid of disorderly conduct as a charge, but rather there is an unworkable balance where you allow vast discretion to arrest someone. Neil Gorsuch has the quote where, based on our laws, almost anyone can be arrested for something at almost any time based on kind of this current status of laws. And if you combine that with then the presence of probable cause will defeat a retaliatory arrest claim, then it basically gives people no redress. And so my argument is at least you can't have both. You either have to severely narrow the laws or you have to give them some kind of redress even when there is quote unquote probable cause, because I'm uncomfortable with removing disorderly conduct like entirely, rigidifying that too much. I'm more on the side of we should give plaintiffs more abilities to challenge retaliatory arrest claims even when officers have probable cause.
Just following, I had a question about sort of what kinds of evidence we think we should use in that chain of inquiry. Did you want to follow up on that one?
Yeah, I definitely think it should be a holistic analysis. There is in the paper I cited, and I'm going to butcher the name, but it's Church of Hailukami Babale. They have a list, and I can pull up the exact list. But they basically give a bunch of different factors, which include like statistics, like general evidence of motive, some legislative history. So they basically give you kind of this laundry list of factors that the court can look at, and then each one of those factors is not dispositive. So I think one of those things is if you see that a particular law is being enforced against one particular racial group very disproportionately, that doesn't in itself prove racial animus, but it increases the suspect scale where you have to then investigate that more. And I think the court should have this basic judgment that when the facial evidence of kind of impermissible motive kind of reaches a certain threshold, then we should burden shift, because it's going to be so difficult for a plaintiff to prove all of these factors completely. So it should be when you see a general abundance of evidence, it should then shift to the government, and the government then should say, oh, okay, well, these statistics look bad, but they can be explained by these factors, and then they have then the ability to defend themselves. So that would be roughly how I imagine kind of a burden shifting helping to address some of these issues.
So it would be something like, in order to survive a motion to dismiss, you would have to at least allege something from that list.
Yeah.
Is there any other thing our panel members want to chime in on before we open the floor to questions? Okay.
Good.
Do we have some questions from the floor? Yes.
Hey, Enrique Armijo, 3 p.m. speaker. Alec, I wanted to talk about your first point and a couple things that Emerson highlighted about it. One place to look with respect to kind of the difference between online speech and in-person speech is there's an emerging scholarship around online incitement that talks about kind of the mob versus screen problem. And a lot of that commentary, and I would kind of put myself in this category, I think, says that you basically can't have online incitement because you can't have imminence if you're speaking online. So that would kind of maybe be one way to talk about this difference. And the other, on the same point, I was wondering if you think the presumption should go in the other direction. So in other words, to say that a court, and I think this is going to increasingly come up, you think maybe in the Packingham versus North Carolina example, where you have someone who the government says as conditions of your release you can't speak online, and somebody then challenges that as a speech restriction, and the court says, well, there's no problem with not letting you speak online because you can speak in person, right? I think you would say that the rule should go in opposite directions, but I think that might be something that you could might be worth unpacking a little bit as well.
Yeah, I think that's a fantastic point, and I would be because online forums are different from physical forums, I think, yeah, it should cross both ways. And so if you say, you can't speak online because you can speak in person, it's not necessarily going to be an equivalent standard. So I think that standard would kind of cross-cut. I would also mention Enrique has a brilliant article on the flaw with the ample alternative channels doctrine, which was very influential kind of for that first section of the paper. So I would highly recommend checking that out as well.
You have some hands back there. You want to?
Hi, my name is Doron Dorfman. I'm an associate professor of law at Seton Hall Law School. I'm not a free speech scholar. I am a health law and disability law scholar. But I do want to make a recommendation. It's not a question, it's a recommendation. So there's a really great 2021 article, Rethinking Disorderly Conduct by Jamelia Morgan. which talks about how the idea of disorderly conduct influences minorities, whether they are people with disabilities, whether they're people of color, and I think that could be very helpful to the discussion, and I really enjoyed and learned a lot from you.
Thank you so much. That's a great recommendation.
Hi, Eugene Volokh from UCLA. So, in theory, the time, place, and manner doctrine is supposed to kick in for content-neutral restrictions, whether on speech or, since we were talking about the Clark v. CCNV, on expressive conduct. And the premise is, speech and expressive conduct have a communicative portion, which the government generally can't mess with, but they also have a non-communicative portion. They may make parks much less appealing to other people. They may block traffic. They may provide a cover for violent attacks. And in at least some of these situations, the theory is that allowing certain kinds of speech interferes with other people's activities, including their own speech. So if a park is all taken up by people protesting, or perhaps people sleeping, although it may be somewhat different, other people can go to the park to hang out and talk to their friends. Or if there is a parade down a street, other people can't drive down the street, or a spontaneous demonstration in the street, can drive down the street, including they can't drive to their church. They can't drive to their kids' school where First Amendment protected activity takes place. So my understanding of the ample alternative channels doctrine is it's always been an attempt to try to mediate between competing uses, especially of public space. Interesting question how it plays out has been extended to activity on private property, but historically it was public property. So if there is a very big protest, it interferes with other uses, and you could say, well, the protest always wins. And as between other free speech things, well, first come, first served. So if you throw a protest, well, too bad that somebody else a few minutes later wants to use that street to get to someplace. Well, they need to wait or find another path or park the car far away and take their kids past this large mob of people. So you could say that, but I think the court has not been terribly satisfied with that solution. And finally, one other example, which isn't exactly about speech, but residential picketing, right? The theory, of course controversial in Frisbee v. Schultz, it was a 6-3 decision, is if I organize a large protest outside your own home, that's a real intrusion on your privacy. And it's true the alternatives of marching past the home or doing something else somewhere else are not perfect. They're not equivalent. But they're close enough given the fact that there is this non-communicative effect of having a mob of people outside of your house. So how would you deal with this, and especially with a situation where people are saying, look, this person's large protest activity is interfering with my ability to engage in First Amendment protected activities?
Yeah, I think it's a really great question and is a very tough dilemma, and that's why I'm critiquing the time, place, and manner doctrine, but I'm not saying we should get rid of it, because we need these certain restrictions that can help manage competing uses of space and the ability for different people to speak. I do think that the courts have been too deferential to systems like of order, and that if we want to have enough breathing room for First Amendment activities to survive, we're going to have to tolerate some losses to aesthetics. We're going to have to tolerate some maybe interferences, a little reasonable interferences, possibly like with privacy or kind of uses of public parks that all people may not completely enjoy. I do think there will kind of cross a line where we do have to manage space, such as you can't have a protest that completely takes up a public park. And we were talking about timing, and I think this will be an interesting discussion of if they then occupy the park, for 2 weeks, is that a use of a space? And so my rough stab at how I would kind of address it, but I would be very interested to hear kind of from the panelists, is that you can dedicate in advance the standards for how the forum will be used. So is it a first come, first served basis where you can only, use that space for a set period of time, and then maybe that's your right to the forum. And then, as I mentioned, I think when you're using the ample equivalent standards, one of the exceptions is it's only equivalent standards that you have the right to use in the first place. So if you don't have the right to exclusively use the public park at all hours or to litter in the park or do these kinds of things, then you can't come to the ample equivalent channels standard for protection because it only relates to things that you have a right to do. And so I do think that we can set constraints on like what individuals are able to do in parks and how much space they're able to take up, how long they can occupy it, and whether or not how much damage they can inflict on the park. But I worry that the current doctrine, by not relying on an equivalent standards test and being very deferential to government officials, allows the government way too much ability to police kind of dissent and disorder that kind of comes with social movements at the expense of free expression. But I know that that's probably a pretty unsatisfactory answer.
I would just chime in to say that I think this point came up earlier, but as much as we want clear standards and we need the clarity, I think this specifically is always going to be a very fact-intensive inquiry, right? So we were talking about all these examples of the street, but you can think about even if we had something that gave some clear direction about, streets or public places or time frames, it really matters whether you're in Graham, North Carolina, or New York City, or Arlington, Virginia, and whether the park has a playground that 2-year-olds use all the time, or is a park that's known as People's Park, or whether it's a park that, all of these things. I think, we all have the strong reaction that having to reroute yourself maybe to daycare is not the worst thing in the world. As a parent, I know it's annoying, but some level of annoyance is going to have to be absorbed. And I don't see any way around at the end of the day it coming down to the judge's sort of thumb in the air, like how much inconvenience is too much, like how much, given the circumstances, given the totality, given all where we are, who we are, what the streets are, who lives here, what are they doing on a daily basis. At the end of the day, they're going to have to decide what is too much inconvenience, and I don't know how much clarity we can give them, given how the broad variety of circumstances we think we can come up against.
Yeah, I mean, I think Eugene, identifies the problem, right? Public expression is inconvenient, costly, messy. What do you do about that? I mean, my default is to say, if you're talking about a public park, time out of mind, open for the expression of ideas, immemorially set aside in trust for the people to express themselves. There's no First Amendment right to recreate or frolf or to pick up your dry cleaning. I mean,
How do you spell that?
If we're weighing the fundamental right to speak in public against any of these things, I think it often ought to win. Not always, right? I don't think you have a right to occupy a space 24 hours a day, right? There are health concerns, there are all kinds of problems that arise there, but I also think it's dismissive of courts and the court sometimes to say, well, you can't burn your draft card to protest the Vietnam War, but you could write an op-ed. What's the difference, right? And then in another breath, in a different case, saying there's an emotive power to speech, and we should be very careful to protect that and make sure. So I think when you get into this context, I think the sort of order considerations have balanced out free expression rights more often, I think, than they should have. But I take your point, right? There are inconveniences to this. There are costs to it. People don't like it. They react to protests by saying it's, when the 2020 protests were going on in my neighborhood, I live in Richmond, people are like, well, you shouldn't be able to do this, period. You shouldn't be able to protest in a residential area. What about the people's sleep? What about their comfort and so forth? And I just said, well, there is a cost to be paid for having this right. And I think we should be willing to pay it, generally speaking. So that's just, my own perspective, my own bias, maybe.
I mean, the one way that this came up in the Graham, are we on time? We're okay. The one thing that came up in the Graham, North Carolina case is it was a public park, but it was outside of a courthouse, right? So then we're thinking about, it's a public park out in a public space next to a seat of government. So what could be more hallowed First Amendment ground than that? And there's important business that's going on inside, right? So part of the inquiry when we're talking about outside of government buildings, at least, is about, are they able to function inside, right? Like, you can make noise, but you can't make so much noise that they can't actually do their work. So I wonder if there's some sort of like basic functioning of the, you know, maybe the neighborhood is basic functioning is letting people sleep, but you're not interfering with like the function of a neighborhood by raising a little bit of a ruckus once, you know? So I think that inquiry around, is the space able to continue to be used despite the inconvenience for its basic purpose, might help inform the inquiry a little bit.
I also think there is that remedy as well. If the costs reach a very drastic level, you can still meet you might, if it's truly very severe and compelling cost, then you could meet a strict scrutiny analysis. And so I think if you look at like protests that are disrupting like sleep at night, like 2 a.m. Like protests, then I actually think that could very well survive a strict scrutiny review, so long as it's a narrowly tailored kind of restriction on that. And so that's at least a fallback position to prevent, you know, super severe losses.
I mean, I don't know. I wonder how easy even that, I mean, you seem to be very sanguine that strict scrutiny would easily take care of that problem. So what are you saying? The compelling government interest is to let people sleep, to protect people in the vulnerability or the privacy of their homes? I mean, but yet in like the cases with, you know, the TPM restrictions on protests in front of abortion clinics, the argument could be, well, wait a second. I mean, your home is not the only place where you're vulnerable. If you're a woman who is seeking reproductive health services, you're probably in a vulnerable state. And maybe there's reasons why, if you're going to protect people sleeping at home, it's worth having some sort of protections of people who are trying to access that facility, right? I mean, you know, and yet that seemed to be an example where you thought this was clearly a, you know, viewpoint or at least content-based discriminatory thing. And okay, all that means is it needs strict scrutiny. So how are judges going to decide that, you know, the one passes strict scrutiny and the other doesn't? Or
Yes, and I think that's a tough issue that you raise. I think, and I would need to research it in more. And when I'm revising the paper, I'll definitely look into this. But I think something about the home and then like the property rights that kind of extend within like a sphere outside of the home, not a completely absolute sphere, but that might make the cases relevantly different rather than a public street. But no, it is a tough issue. I don't have a clear-cut answer at it yet.
do we have any other people who want to chime in from the, yes, we have some. We can do one last question.
Hi, good morning. Andrew Huang. Regarding specifically the closer analysis or closer scrutiny of legislative intent in First Amendment-related regulations, in this panel's research, have you found that there has been a substantial set of evidence to point to this legislative intent or legislative history as it regards to content-based regulations, or have you found that it's been a complete black box? Or has been impermissible animus been so obvious that you don't really need a lot of evidence?
Well, I can, the example that comes to mind, which is not a protest case, but when we have we have a case in Oklahoma around a ban on inclusive education, and part of our allegation is that it was passed with racial animus and has a racially disparate impact. And so we have introduced, well, we did this in Oklahoma. We also have done it in Florida, where we challenged the Stop Woke Act. Sorry, it's actually the Florida example that I'm thinking of, where we provided similar examples in both cases, where we cited legislators from the floor, from the session, saying we're doing this because we don't like Black Lives Matter, point blank. And the Oklahoma case is still languishing. We're hoping that the district court will rule at some point. It's been 2 years since we filed for our preliminary injunction. But in Florida, we actually won the preliminary injunction. The law has been blocked with regard to higher education, but the court rejected the statements by the legislators as irrelevant. And he basically said, look, that is not, I'm finding that the law is unconstitutional on its face and as applied to these individuals. But what one legislator said is not, and you said this in the paper, right? Like, that does not encapsulate a legislative motive. There's no such thing as a legislative motive. There's lots of legislators who vote for lots of reasons, and you come out with a law that does something, and you might have what the sponsor intended it to do. You might have what lots of supporters intend it to do, but I think courts often are skeptical that you can say this is what the government wanted to do, given that it's so multifaceted and given that people act for all sorts of different reasons.
All right, thank you. We have reached the end of our time. We are now going to be taking a 20-minute break, and we'll reconvene at 11 o'clock for our second panel of the morning. Thank you, everyone.
Thank you.